Good morning, everyone. Welcome to Assembly Judiciary. We'd like to welcome everyone here in Las Vegas, and happy to see our youth with us today here in Carson City. They're in Las Vegas, and anyone watching on the line through YouTube or our Nellis station. With that, Secretary, please take the roll.
Assemblywoman Bilbray Axelrod. Assemblywoman Cohen. Assemblywoman Considine. Assemblywoman Gallant. Assemblyman Gray. Assemblywoman Hanson. Assemblywoman Hardy. Assemblywoman LaRue Hatch. Assemblywoman Marzola. Assemblywoman Mosca. Assemblywoman Newby. Assemblyman Orentlicker. Assemblywoman Summers Armstrong. Assemblyman Urick. Chair Miller.
Here. And please mark Assemblywoman Bilbray Axelrod present when she arrives. With that, just a few housekeeping items before we jump into today's agenda. First, friendly reminder that any materials that you need for your presentations, please make sure they're in by noon the day before. Also, a reminder to everyone in the room to please turn off any sounds on any of your electronic devices. And also, this would be a great time to just put out in legislative world. If you are still developing amendments for any of your bills, this is the time to get them in. So, with that, we have two bill hearings. The first one will be AB 272, presented by Assemblywoman Monroe Moreno, Beth Schmidt, and Shad Matheny, who is with us at Grant Sawyer. This measure establishes provisions relating to mail theft. And members, you were just handed the latest edition of the amendments because Assemblywoman Monroe Moreno knows this is the time for amendments to get them in. So please work off of the ones that we were just handed by committee staff because this is the latest edition. Assemblywoman, your bill hearing is open, so we are ready whenever you are.
Good morning. And I work right up into the minute before the hearing. Thank you, Chair Miller and the Committee on Judiciary. I am Assemblywoman Danielle Monroe Moreno. I represent Assembly District 1, which is in Southern Nevada, and I call it the best district in the state. That's why it's number 1. And we are here today to present Assembly Bill 272. I have with me today for presentation Mr. Shad Matheny. He is a U.S. Postal Inspector. He's down south on Zoom. And sitting with me here at the table is Director Beth Schmidt with the Las Vegas Metropolitan Police Department, the Office of Intergovernment Service. With the Chair's permission, we'll provide a brief background of the information and the summary of the bill, and you have before you what I hope to be the last amendment to the bill. Mail theft is a serious crime that can significantly have consequences for individuals, businesses, and organizations. Mail often contains sensitive personal information such as bank account details, credit card statements, and social security numbers. If this information falls into the wrong hands, it can be used for identity theft. Mail theft also results in financial losses for individuals and businesses. For example, checks or credit card payments stolen from the mail can be cashed or used to make unauthorized purchases. There are also legal documents sent via mail, such as contracts, deeds, and court documents that can be stolen, leading to legal disputes and financial losses. The disruption of services for businesses and organizations rely on mail for communications with clients, suppliers, and customers can affect their operations. And finally, we as a body made a policy decision to go to mail-in ballots. While we have not seen a large number of fraud concerning our elections, knowing that those ballots are in the mail with personal identifying information kind of lets AB 272 take care of a problem before we see it coming. Both federal and state laws play an important role in preventing and prosecuting mail theft. Federal laws provide a foundation for addressing mail theft issues involving U.S. Postal Service mail, while state laws can provide broader coverage to address mail theft issues involving all mailboxes. This is the intent of AB 272. As you know, we have submitted a amendment this morning. I will now, with your permission, turn the presentation over first to Mr. Shatley in Las Vegas and then to Beth here in Carson City.
Thank you. Shad Matheny, U.S. Postal Inspector. The United States Postal Inspection Service investigates crimes involving the Postal Service, its employees, and the U.S. mail. One of our primary focuses here in Nevada is the theft of U.S. mail and the subsequent identity theft and other financial crimes associated with it. Nevada is currently ranked 5th in the nation in identity theft reports and 3rd in fraud reports. These combined frauds and scams resulted in more than $100 million in losses in the state in 2022. Nevada also experiences one of the highest incidences of volume mail theft in the country. Individuals involved in mail theft are nearly always also involved directly or indirectly in identity theft. A 2020 report by NBC based on Freedom of Information request data showed that mail theft reports increased by 600% from 2017 to 2020. A Las Vegas Review-Journal article in 2022, also based on FOIA data, showed there had been 3,124 complaints about stolen or missing mail in just Las Vegas from February 2021 through March of 2022. The federal system generally does not have the resources to prosecute all federal offenses, so they enact thresholds to identify cases appropriate for federal investigative attention. Most simple mail theft-related cases are charged in state court because of this, and those charges are made for some related crime, such as forgery or an identity theft-related charge. In Nevada, postal inspectors are authorized under NRS 171.1257 to make probable cause arrests for offenses related to postal matters. However, as there is no mail theft statute, law enforcement officers, including postal inspectors, are generally only able to charge a financial crime such as forgery or credit card fraud that resulted from the mail theft. These crimes may not even be committed by the same individual that committed the mail theft, and therefore the original act of the mail theft may never even be charged. A law directly classifying mail theft as a felony violation will enable deputies, police officers, and postal inspectors to charge a felony for possession of or theft of mail, possession of the keys or tools used to illegally open mailboxes, and prying mailboxes open to obtain mail illegally. This will result in an improvement in the way law enforcement is able to prevent identity theft and financial crimes resulting from these types of crimes. Because the sole purpose for and ultimate result of mail theft are serious financial crimes such as forgery, credit card fraud, and identity theft, and these crimes create a serious hardship on residents who then need to remedy or repair issues impacting their financial security or identity, this bill is vital. Thank you.
For the record, Director Beth Schmidt, SCHMIDT, with the Las Vegas Metropolitan Police Department. I want to thank Assemblywoman Monroe Marino for asking me to present with her. Prior to my current position, I spent 3 years as a financial crimes sergeant with the Las Vegas Metropolitan Police Department. And in that role, I saw the result of mail theft on a daily basis. LVMPD Financial Crimes Section investigates between 400 and 500 financial cases every month. A large portion of those cases, including identity theft, fraud, and forgery, stem from mail theft. So how does the crime of mail theft work? Criminals will target residential community mailboxes. Those are the silver mailboxes that you have located on your street. The criminals will either pry the box open, or more commonly, they will use stolen postal keys or homemade keys to open the community mailbox. In less than a minute, they open the box, remove all of the mail. They throw it into a vehicle and move on to the next street and do the same thing. They'll do this in broad daylight. Eventually, they sift through the mail and take the cash, they take the checks, and anything with personal identifying information. One of the things they'll do is they'll wash the check, that check that you wrote to your niece or your nephew or granddaughter for $25 for her birthday. They'll wash that, they'll put another name onto it, they will put a different dollar amount onto it, and they will cash it with an ID. And that ID they will have manufactured from a previous mail theft victim. So some of the ways criminals will use this personal identifying information they obtain through mail theft is they will create credit cards, IDs, and driver's licenses. They'll take out home and car loans. They'll lease apartments, and they'll open bank accounts and utility services. So you may ask, how many mailboxes are broken into each day? Well, we don't track that because breaking into a mailbox isn't a crime in the state of Nevada. Mail theft is a federal crime. Nevada's a large state and it's a rural state, and the United States Postal Inspectors only have a handful of inspectors to assist local Nevada law enforcement. And this is why Assemblywoman Monroe Marino has brought forth AB 272, because in the state of Nevada, if law enforcement catches someone breaking into a mailbox, we don't have an NRS to charge them with. If we stop a vehicle with a backseat full of hundreds of pieces of unopened mail, we don't have an NRS to charge them with. If we recover bags and bags of unopened mail during the service of a search warrant, we don't have an NRS to charge them with. The only NRS that we have in relation to mail theft is a gross misdemeanor charge for the possession of a burglary tool. And that's what we use for possessing a stolen United States Postal Service mail key or a homemade mail key. And it's important to note that postal keys are considered so valuable by mail thieves that it's not uncommon for mail delivery people to be robbed of their keys at gunpoint. The keys give criminals access to an unlimited amount of mail, which is really access to an unlimited amount of personal information about people. So when you think of AB 272, this is about acquiring and possessing stolen mail, postal keys, and personal identifying information. We have existing NRS for law enforcement to use to charge someone for using that personal identifying information. AB 272 is a much-needed tool for law enforcement in Nevada to combat mail theft and help prevent identity theft, fraud, and forgery. We believe AB 272 will help address these issues.
Thank you, Madam Chair. Danielle Monroe Moreno for the record. With your permission, I'll just quickly walk you through the bill. Thank you. Section 1, subsection 1 of the bill explains the circumstances under which a person commits the crime of mail theft. This includes 1, knowingly, willfully, and with the intent to deprive, injure, damage, or defraud another, takes, destroys, hides, or embezzles mail, or obtains any mail by fraud or deception. 2, buys, receives, conceals, or possesses mail and knows or reasonably should know that the mail was unlawfully taken or obtained. 3, buys, receives, conceals, or possesses a USPS key that provides access to certain mail receptacles or a counterfeit device or key designed to provide access to the lock mechanism of such mail receptacles. And 4, knowingly, willfully, and with the intent to steal the mail inside, damages, breaks open, tears down, takes, or destroys any mail receptacle. Subsection 2 provides the penalties for the crime of mail theft. The proposed amendment revises the penalties in the bill. The amendment deletes paragraphs A and B in Section 1 and subsection 2, thereby removing the reference to the gross misdemeanor and the monetary value. A person who commits mail theft is guilty of a Category D felony. And in subsection 3, it requires the court to order a person to pay restitution. And lastly, subsection 4 provides definition. And with that, Madam Chair, we will stand for questions.
Thank you, and thank you for your presentation. With that, our first question will be from Assemblywoman Considine.
Thank you, Madam Chair. Thank you for this bill. I'm sure many of us are aware or have been victims or live in a neighborhood that this has happened. But I'm looking at the wording and I just want to make sure that I have this right and clarify. In section 1, sub 4, A, it defines mail, letter, postcard, parcel, package, etc. And then on the very last line of the bill, it includes postal service means the United States Postal Service or a private common mail carrier. My question is, if we're listing parcels, packages, some of those mailboxes have the keys where you need to get those parcel packages out. Some people have mailboxes at their house where people put parcels and packages in. I just want to clarify, does this include packages that are delivered by UPS, FedEx? Does it include anything that we as maybe aware of all of this verbiage, what we all consider mail?
Danielle Monroe Moreno, for the record, it is our intent with this legislation that it would be all-encompassing of all mail delivery.
Assemblywoman Cohen has a question.
Thank you, Chair, and thank you for the presentation. I didn't catch you say this, but I don't know if I missed it when I was looking at the amendment, but I'm assuming a lot of this is organized crime. And will this bill give the DAs the tools they need to charge for the crime when it's organized? So as opposed to just one person going out and doing this, that if there are going to be enhancements, that type of thing, will this help with that?
Beth Schmidt, for the record. I can tell you in our experience in the Las Vegas Valley, it doesn't appear to be a organized crime. It tends to be smaller groups that are doing it. We haven't come up against that, but perhaps Shad can speak to that.
And if I may clarify, and to clarify, I don't mean organized as in like the mob, but I mean an organized group. I do mean an organized group of people. Yeah.
Right, Beth Schmidt, large groups.
Right.
We don't typically see it as large groups. It tends to be a couple of people at a time.
Right, but even with a small group, well, I'll just go to Las Vegas, but I guess I'm thinking even with a small group, there are some ways to charge for that organization, not just for the crime itself, but for organizing and then committing the crime.
Yeah, that might be something more appropriate for the DAs to answer to.
Okay, so we'll leave it there. Next question from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for bringing this. I think this is a very important bill and is filling a gap in our statute that I don't know that all of us knew was a hole in the statute. And I also appreciate going after porch pirates, so anytime we can do that. My question is with the keys, and I understand we need to put that in statute, but I just want to clarify as I'm reading it. It says, if you buy, receive, conceal, or possess any key to any lock adopted by the United States Postal Service. A postal worker receives a key when they go out and they do their job. I just want to make sure, is that language clear enough that someone who is supposed to have that key is not getting caught up in this language?
Danielle Monroe Moreno, for the record, yes. A postal employee, part of their job and the tools that they need to do their job is to have that key. But what we found is that postal workers are being held hostage for someone to steal that key. And then the person that steals that key makes copies of the key, and then they sell them to other people who are not supposed to have it, and it's not in the operation of their job. We're also finding, and I believe Beth can attest to this, where people are stealing uniforms to put on as a postal worker uniform so that when they're in their neighborhood, a neighborhood stealing, people don't notice that it's a theft, that the person's a criminal because they've stolen a uniform. Could be years older, but I don't know, and I'm sure you don't know how often postal uniforms change with that stolen key. So would not be held against anyone in the commission of the normal operations of their occupation.
And Beth Schmidt, for the record, I can confirm that I personally had a guy delivering mail that was not, he didn't work for the Postal Service. We didn't realize it till afterward. We just thought he was a contractor. And he took everything out of the mailbox right in front of me one day. No idea until after the fact the neighbors put that together. But we do see the cobbled together postal uniforms, but unless you work for the Postal Service, you wouldn't know that they're cobbled together. But we find them on search warrants as well. And the keys are a weekly occurrence that we will find keys.
Thank you for that. Our next question is from Assemblyman Urick.
Thank you, Chair. And as a prior law enforcement officer, I can tell you this is very much needed. To follow up on my colleague's question, by establishing this as a specific state crime, would it also help our local law enforcement and our prosecutors bring a charge of where there are maybe not large grand, but even a few players that are conspiring together to bring a charge of conspiracy to commit a crime to address those concerns?
Beth Schmidt, for the record, it is my understanding that we could do that, but I will say that in our experience, we tend to see the sort of one-offs, one or two people working together. But if we could articulate that, yes, I believe that it would allow us to do that.
Thank you for that question. The next question is from Assemblywoman Hardy.
Thank you, Chair. I'm too really happy to see this bill. This happened to us in our neighborhood, and it's scary because, you don't know what was in there, and, that credit card companies send out applications for credit cards, and then you've got to go through and lock all your credit files, and it's, you just feel violated. And so following up on what you said, it's hard to catch them because, like, in our neighborhood, someone did this like in the middle of the night, and there was a neighbor out there and saw it, but then it's so hard to catch them, right? You're going around seeing if somebody caught it on their Ring camera or something like that. So I'm just curious, I guess the most common way that you catch these people is, like you said, you pick them up for something else, and then you discover large amounts of mail, or because that's just, and I know there's really not much you can do, but I'm just wondering, is that the most common way that you catch these individuals?
Beth Schmidt, yes, like catalytic converters, this is a really quick crime to commit. So oftentimes we will see it on Ring cameras, but at night it's very difficult to determine who that person is. More often than not, and this is why we put in the possession aspect to this bill, more often than not, what we come across is someone that will have a backpack full of mail, or the back seat of their car, or in a house, bags and bags and bags. And what we'll see is the sequential order of the mail by address. So it'll be, 3500 West Tropicana, number 1, and there'll be a stack of these. Apartment 2, there'll be a stack, apartment 3, and then it'll be, 3100 West Tropicana, 3101 Tropicana. And so you can tell that when we work with Postal, we can determine that these came from the same bulk boxes.
Proceed.
Thank you. And then this might be for the gentleman in Las Vegas. So what happens, is there coordination? Like, I remember asking our mailman, well, what do we do? What happens? Like, do you guys report this? Or so what does happen? Is this like, if there's like the central box is broken into, do they contact law enforcement, or how often do they rekey those boxes? What happens as far as on the postal side?
Yes, thank you. Shad Matheny, Postal Inspector. When we receive the reports of mail theft or compromised boxes from the public or from other law enforcement, Postal Service does work to fix, repair, or replace those boxes with higher security boxes and or higher security keys and locks if needed. So yes, that's pretty much the process.
And Beth Schmidt, I'll just add to that the coordination between the Postal Services, the federal entity, and the local law enforcement is quite high, but you have to understand that we have the benefit in Washoe County, and we have the benefit in Clark County that we have postal inspectors located there, but for some of our rurals, it can take a long time until someone can get out to repair that box. And the chance of an investigator being able to get out on just one neighborhood box is just based on their sheer number, how few employees they have. This gives us a real tool to be able to charge for breaking into that box.
Our next question is from Assemblywoman Newby.
Thank you, Madam Chairwoman, and thank you, Assemblywoman Monroe Moreno, for bringing this. I had no idea this wasn't already on the books. this bill seems to focus on the time in which the person already has the key, goes to the box, steals the mail, is in possession of the mail. But based on your testimony and the robbing of the postal carrier is also of concern, obviously. What sort of charges are brought against that, and are there any sort of aggravating charges that can be brought? Obviously, they're being robbed or at gunpoint, hopefully not harmed, but are there any aggravating charges if they are robbing someone for the purposes of taking a key in order to commit further crimes? How does all of that go? And perhaps that's also for the postal office person.
Thank you, Shad Matheny. Yes, the robberies can be charged in either state court or federal court, and they are pursued aggressively in the federal system if there is a robbery of a carrier for those keys. We have charged cases in both venues.
And Beth Schmidt, I'm not aware of an enhancement at the state level for that, but it would be, depending on what the circumstances of the crime were, assault with a deadly weapon, robbery, depending on the age of the person, the mail delivery person, there might be an enhancement there. But I'm not aware of an enhancement at the state level for mail theft or for U.S. Postal Service.
Thank you. Our next question is from Assemblywoman Hanson.
Thank you, Madam Chair, and thank you for being here. I just need some clarification because I did always understand it to be a federal offense. So I'm understanding that we need this in statute to enable our local law enforcement to be able to deal with this. So would there be charges both federally and depending on what's stolen? I was looking up that some states you have both. They have the local laws, and then they also bring a federal charge as well. I'm assuming there's that ability. And then just real quick to clarify, this would make it a category D felony if there's no monetary. If I read the amendment right, or maybe no, maybe. Well, Category D felony, and it is a felony on the federal level as well. So we're kind of matching that. Did we leave in, if it's not monetary, that on the local level that it would be a gross misdemeanor? Okay, so it's still just a Category D. Okay, I wanted to see about that matching the federal statute. So I'm sorry, back to the idea about would there be a federal charge and a local law enforcement charge as well, depending on the seriousness of the crime.
Yeah, Beth Schmidt for the record. The way that we work in Las Vegas is we work really, really closely with Postal because we have that benefit of they are located in Vegas and there are multiple investigators there. What we will do is on some of the cases where we have significant amounts of mail and uniforms and significant number of keys, Postal will come out to the scene, and then the decision will be made by the supervisors about and consulting with the U.S. attorneys about and our district attorneys, which is the best case and the best direction to go. But the vast majority of these cases, just based on manpower, are dealt with by local law enforcement. But yeah, on anything, the feds will typically have thresholds, and Shad talked about that.
We have a question from Assemblyman Gray.
Thank you, Madam Chair. And I was just wondering, in the interest of costs and manpower and everything else, if local law enforcement can have the authority to investigate it, but then refer it to the feds for charging and prosecution, and let them go off to federal prison and let them absorb the cost on it.
And that goes back to depending on the totality of the circumstances and us being able to put that case together and then working with Shad and his team from U.S. Postal. Yeah, sometimes if we feel, the U.S. attorneys feel we have a good case, then we will take it the federal route.
Thank you. And with that, we have no further questions, so I will open it up for testimony in support of Assembly Bill 272. We'll start here in Carson City if there's anyone that would like to come forward and testify in support. While people are approaching, I will give out the phone number for today. The number is 1-888-475-4499. The meeting ID for today is 811-095-86444. And with that, let's proceed with our testimonies.
Good morning, Chair and members of the committee. For the record, my name is Dylan Keith with the Vegas Chamber. On behalf of our smallest business members who truly just rely on mail security, we are very much in support of this bill, and we would like to thank the sponsor for bringing this piece forward. Thank you very much.
Just a reminder for everyone to state and spell their name as well. Thank you.
Good morning, Chair Miller, members of the committee. My name is Greg Herrera, G-R-E-G. Herrera is H-E-R-R-E-R-A, representing the Nevada Sheriffs and Chiefs Association. The Nevada Sheriffs and Chiefs Association is in support of Assembly Bill 272 and would like to thank Assemblywoman Monroe Moreno for bringing this bill forward. Mail theft continues to be a significant challenge for law enforcement across Nevada, leaving behind a tremendous impact for those victimized throughout the state. As stated during this presentation, mail theft often leads to identity theft, account takeovers, credit card fraud, amongst other crimes. Victims often face severe credit damage and spend months or years trying to fix the damage that was done. This bill gives local law enforcement the ability to go after mail thieves with local charges rather than rely on postal inspectors who often stretch thin while attempting to cover a large assigned territory to make time to come out and assist in investigations. This is especially challenging in rural counties in Nevada, as those postal inspectors are usually not able to make it out to those locations, with the more large caseloads being in Clark and Washoe counties. As a former financial crimes investigator, I've served search warrants at a number of locations and located multiple trash bags of stolen mail, only to be told that it didn't meet federal thresholds for prosecution. This is a local problem that affects citizens and businesses of Nevada. The Nevada Sheriffs and Chiefs Association would respectfully request that you join us in supporting AB 272. Thank you.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association in support of Assembly Bill 272, and that's J-O-N-E-S. We are in support of this bill, and it does fix a hole in our statutes now with respect to this type of information. We do currently have possession of personal identifying information crimes, but those crimes really focus on the intent. In other words, the reason that the defendant is possessing those particular pieces of information. That could be a name, a social security number, and they could be possessing it for to create a false status for themselves, and that would be a category, I believe, E felony. Or they could be possessing that information to commit some type of fraud. And I, as the prosecutor, would have to prove beyond a reasonable doubt that one of those reasons is why they're possessing the mail. But oftentimes what we see, as the testimony alluded to, is just people who possessing a big bag of mail, and we don't quite know why they're possessing it. It could be for any of those reasons, but I can't necessarily prove that beyond a reasonable doubt. And what this does is it plugs a hole in that gap by saying if you possess it and I can prove that you knew or reasonably should have known that it was stolen, then the crime of mail theft would have been committed. And with respect to Assemblywoman Cohen's questions, we do have conspiracy, so the gross misdemeanor conspiracy, if we can prove that people were acting in concert towards the commission of a crime. If I have a forged lab, in other words, we've got mail possessed in conjunction with card readers and things like that, embossing machines, I could potentially prove a forgery lab charge. And for the higher level crimes, we do have racketeering, but I can tell you racketeering is an extremely difficult crime to prove. So with that, Chair Miller, we are here in support of AB 272, and again, I want to thank Assemblywoman Monroe Moreno. Thank you.
Good morning, Chair Miller, members of the committee. Jason Walker, Jasonwaker, Washoe County Sheriff's Office, testifying in support of Assembly Bill 272. I'm definitely dating myself, and some of us in the room may remember when Grandma or Grandma would send you those 9 crisp dollar bills at your 9th birthday. Sadly, those days are over. I applaud the Assemblywoman and with Metro's support for putting this together. This is something that needs to come back out, and with the legal teeth that we have on this now, hopefully these crimes won't be committed anymore. Testifying in support. Thank you.
Good morning, Madam Chair, members of the committee, and staff. My name is Rick McCann, Nevada Association of Public Safety Officers, and a member of the Nevada Law Enforcement Coalition. I personally live in an environment where our community mailbox was ransacked, broken into. It took over 4 months for them to finally get it fixed. I understand that. My mail carrier said 31 of them had been hit in that postal area within a series of like 3 days. It's a bad situation. Got a lot of older people like me who live in my area. They have Social Security checks. They got other stuff coming in. Maybe they're the ones sending the $9, but there's also money coming in. We got to stop this. My people in my neighborhood, hell, they wanted to find the guy and put him before a firing squad. But we'll take a Category D felony for now. We ask that you support this bill. Thank you.
Good morning, Chairwoman Miller and committee members. For the record, my name is Emily Prasad Zamora. That's PERSAUD-ZAMORA. I'm the Executive Director of Silver State Voices that leads the Latin Nevadans Vote Coalition, and today we're in strong support of AB 272. Every day, the USPS and private mail carriers handle sensitive information, including ballots, during election cycles. While the majority of mail is successfully delivered to its intended recipient, mail theft remains a significant issue, which can lead to serious consequences for individuals and businesses. In Nevada, last year, in mid-October, the Las Vegas Metro Police Department issued a warning via Twitter stating, "Mail theft is once again on the rise. Thieves are going after mail-in ballots, credit cards, etc. So please pick up your mail ASAP every day." Given the importance of the mail system and the potential risks associated with the mail theft, it is essential to take action. AB 272 is a positive step towards addressing these concerns. This bill provides additional protections for individuals and businesses by strengthening penalties for mail theft. Nevadans continue to rely heavily on mail for important services, including receiving Social Security checks, medications, and voting by mail. By taking action to address this issue, we can help ensure that the mail system remains safe and reliable for all Nevadans. We urge your support. Thank you.
Not seeing anyone else here in Carson City, is there anyone in Las Vegas that would like to testify in support of AB 272? Not seeing anyone. Broadcasting, will you please open the lines?
There are no callers at this time.
Okay, thank you. Then I will go ahead and open it up for testimony in opposition of Assembly Bill 272. Starting here in Carson City. Not seeing anyone. Is there anyone in Las Vegas? Also not seeing anyone. Broadcasting, is there anyone on the line?
There are no callers at this time.
Then I will open it up for testimony in neutral here in Carson City. Is there anyone that would like to testify in neutral? Is there anyone in Las Vegas who would like to testify in neutral? Broadcasting, is there anyone on the line?
There are no callers at this time.
Okay, thank you. Then I will go ahead and welcome the bill sponsors giving me the look, and she's all set and is going to rush back over to her committee to run right now. So with that, thank you, Assemblywoman, for your presentation, and I will close the hearing on AB 272. Next, we have Assembly Bill 371. This bill is sponsored by Assemblywoman Cohen and will be co-presented with Ms. Surratt and Ms. Jocelyn, who I believe is on Zoom. There we are. Okay. And AB 371 makes various changes relating to parentage. With that, I officially open the hearing for AB 371. So whenever you're ready, please proceed.
Thank you, Chair and Committee, for hearing Assembly Bill 371. Leslie Cohen, Assembly District 29. Again, joining me in Carson City is Attorney Kimberly Surratt, who has practiced law for more than 20 years. Ms. Surratt has immersed herself in reproductive Law, Parentage, and Adoption. Ms. Roz is a fellow with the Academy of Adoption and Assisted Reproduction Attorneys and is on the Board of Trustees for the Academy. And she has extensive knowledge in family law, parentage law, and surrogacy. Moreover, she served for 8 years on the Executive Council and has been the vice chair and then chair of the State Bar of Nevada Family Law Section. In addition, she's a past president of the Nevada Justice Association, having served on their board since 2013. She's lobbied with them as an unpaid lobbyist since 2004, and her lobbying career is long, and she's worked on bills such as Nevada Domestic Partnerships, the Uniform Collaborative Law Act, post-adoption and contract agreements, a complete rewrite of all surrogacy statutes, and numerous other family law, reproductive, and adoptive statutes in Nevada. Also joining us via Zoom is Professor Courtney Jocelyn of UC Davis School of Law. Professor Jocelyn teaches in the areas of constitutional law, employment, discrimination, and family law. Professor Jocelyn is a leading expert in the areas of family law and relationship recognition with a particular focus on same-sex and unmarried couples. Professor Jocelyn's publications have appeared in numerous law reviews, and she's a co-author of a family law textbook. And her commentary has appeared in publications throughout the country. Professor Jocelyn has won multiple awards for her legal scholarship, and she served as the reporter for the Uniform Parentage Act for the 2017 update, and she's an elected member of the American Law Institute. Professor Jocelyn received her undergraduate degree from Brown University and her law degree from Harvard Law School, where she was an executive editor of the Harvard Civil Liberties Law Review. So as a reminder, we've heard a little about the Uniform Law Commission before, but it was established in 1892, and it aims to provide the United States, plus the Districts of Columbia, Puerto Rico, and the U.S. Virgin Islands with well-researched and drafted model acts to bring clarity and stability to critical areas of statutory law across the jurisdictions. The ULC promotes enactment of uniform acts in areas of state law where uniformity is desirable and practical. The ULC consists of approximately 350 commissioners, each appointed by the government of each state in the United States, the District of Columbia, Puerto Rico, or the U.S. Virgin Islands. Every ULC commissioner must be an attorney. Commissioners also often concurrently serve as legislators, judges, or legal scholars. In the realm of family law, Nevada has already passed the Uniform Premarital Agreement Act, the Uniform Deployed Parents Custody and Visitation Act, the Uniform Interstate Family Support Act, the Uniform Child Custody Jurisdiction and Enforcement Act, and the Uniform Child Abduction Prevention Act. So as you've probably heard me say in my day job, I practice family law, and unfortunately our family law statutes in Nevada are not particularly well organized or up to date. They're in some ways kind of cobbled together. They also don't always consider the way families are created these days. So the Uniform Parentage Act does that. The Uniform Parentage Act was originally promulgated in 1973, and it removed the legal status of illegitimacy and provided a series of presumptions used to determine a child's legal parentage. When the UPA was revised in 2002, it augmented and streamlined the UPA, and it added provisions permitting a non-judicial acknowledgement of paternity procedure that is equivalent of an adjudication of parentage in a court, among other things. It also included provisions governing genetic testing and rules for determining the parentage of children whose conception was not the result of sexual intercourse. In 2017, UPA was again updated and as a Uniform Law Commissioner, I was honored to serve on the drafting committee that worked for months and months on updating, again with Professor Jocelyn as the reporter. So currently, 7 states have enacted the 2017 UPA updates. Nevada is one of 5 state legislatures which have introduced the 2017 UPA updates, and 14 states have enacted prior versions of UPA. Before we go into the bill, I just want to talk about a little bit about the NRS chapters that are in the UPA. So mostly the bill is in Chapter 126, which is parentage. Very little of the bill deals with the 125 chapters, which is where custody, divorce, and child support are. Parentage is how we determine who is a parent of a child, and if we have a married man and woman, parentage is usually pretty simple. However, if you have surrogacy or unmarried parents or a same-sex couple, it becomes a little more complicated. So with AB 371, the Uniform Parentage Act works to simplify the process for the families, thereby keeping them out of court to address those issues. So I'm going to walk through the bill, and Mr. Rott will speak about the need for UPA Nevada, while Professor Jocelyn will answer any technical questions. So I'll do a very, very brief walkthrough of all of the sections. So, sections 3 through 26 relate to definitions. Section 27 notes that any reference to mother or father includes any gender. Sections 28 and 29 note sections 27 through 91 are UPA and do not affect parental rights under the law beyond the Act. Section 31 is jurisdictional. Section 32 is related to disclosure of information. Section 33 states what applies to the Act for a mother applies for a father and vice versa as applicable. Section 34 states how a parent and child relationship is established. Section 35 notes a parent-child relationship extends to every parent and child regardless of the marital status of the parents. Section 36 states a parent-child relationship applies for all purposes. Section 37 has the parental presumptions. Those presumptions are rebuttable. Section 38 references the acknowledgement of parentage to establish parentage of a child. Section 39 gives details regarding the acknowledgement of parentage. Section 40 addresses the signing of a denial of parentage by a presumed or alleged genetic parent. Sections 41 through 50 address acknowledgement and denial of parentage forms, including rescission. Section 51 permits the State Board of Health to adopt necessary regulations regarding the acknowledgement and denial of paternity. Sections 52 through 57 go back to definitions and begin the genetic testing section, and that goes through Section 68 with the genetic testing section. Sections 69 states matters to adjudicate parentage are governed by the Nevada Rules of Civil Procedure, except it is otherwise addressed. Section 70 lists who can maintain a proceeding to adjudicate parentage. Section 71 lists who gets notices in cases. Section 72 details jurisdiction. Section 73 details venue. Section 74 has to do with the report of genetic testing. Sections 75 and 76 provide that a proceeding to determine whether an alleged genetic parent or presumed parent, respectively, is a parent of a child may be commenced after the child becomes an adult if the child initiates the proceedings. Section 77 lists who can commence a proceeding to establish parentage, and Section 77 of the bill authorizes a person who claims to be a de facto parent of a child to commence a proceeding to establish parentage of the child if the child is alive and less than 18 years of age, and provides that a person who claims to be de facto parent must be adjudicated as a parent of the child if there is only one other person who is a parent or has a claim to parentage of the child, and the person who claims to be de facto parent can demonstrate certain facts by clear and convincing evidence. Section 78 addresses the rules if there is a challenge and there is an acknowledged parent. Section 79 addresses a challenge to adjudication when a child has adjudicated parent. Section 80 lists more proceedings to adjudicate. Section 81 authorizes a court to adjudicate a child to have more than two parents if the court finds the failure to recognize more than two parents would be detrimental to the child. Section 82 allows for temporary child support. Section 83 permits the combination of proceedings. Section 84 permits the commencement of proceedings prior to the birth of the child. Section 85 permits but does not require a minor child to be a party and requires a guardian ad litem in certain situations. Section 86 requires adjudication of paternity without a jury. Section 87 addresses dismissal without prejudice. Section 88 addresses fees and the child's name change. Section 89 addresses who is bound by an acknowledgement. Section 90 refers to the importance of uniform law. Section 91 has to do with signatures. Section 92 relates to the death of a parent when a child is conceived by assisted reproduction during the period between the transfer of the gamete or embryo and birth of the child. Section 93 addresses termination of gestational agreements. Section 98 through 106 makes various other changes to the provisions of existing law concerning assisted reproduction and gestational surrogacy. And Section 99 in particular includes that a donor is not a parent of a child conceived of assisted reproduction, and the consent of the spouse or domestic partner of a donor is not required. Section 101 addresses failure to consent on the record does not preclude a finding of parentage if there is clear and convincing evidence of an agreement under certain circumstances. Section 107 addresses the requirements of an enforceable gestational agreement. Section 108 addresses the impact of marriage or domestic partnership on the of the gestational carrier on the gestational agreement. Section 109 addresses noncompliance with the gestational agreement. Section 135 requires LCB to make appropriate language changes. And sections 194 through 97, 110 through 133, and 136 of the bill make conforming changes to reflect the revisions made to existing law because of the establishment of the provisions modeled after those of the UPA. And sections 28 through 91, or in sections 28 through 91, and the repeal of unnecessary provisions is in section 136. So with that, I will turn it over to my colleague.
Thank you, Assemblywoman Cohen, and I want to appreciate her for her endurance on this bill. Kimberly Surratt, for the record, S-U-R-R-A-T-T. It's taken us a couple of sessions to get to this point, and you probably understand when you look at the depth of this bill, because the drafting, one, the drafting effort, two, the vetting effort to get where we are today was a significant task. Over the years, Nevada was one of the first adopters of the Uniform Parentage Act from 1973. And really, honestly, it's still intact. That's what's kind of there. Over the years, I have come in front of this body and made numerous changes through numerous bills to modernize some of our parentage statutes, adopting bits and pieces and parts of the UPA, the newer versions of the UPA, because I didn't have quite the endurance yet to want to have to go through this drafting effort to do the whole thing all at once. So over the years, I came in front of this body for gender neutralizing on parentage, to ask for updates for our assisted reproduction laws. In 2013, we adopted pretty much all of that. There's a few minor changes to reproductive law still in this bill that we're going to adopt from the newest version, or asking to be adopted from the newest version. But Nevada's been on a roller coaster with family law, and you may be asking yourself, why on earth would we as family law practitioners want to have to comply with this much crazy logistics and procedures? We're thrilled. The family bar is thrilled. We're excited because a lot of this we do by just arguing in front of our judges and have nothing to hang our hat on and hope for. Situations, probably the primary situation this helps with is somebody's put down as the father and believes he's the genetic father, raises the child for 10 years. Genetic father comes out of the woodworks probably through Ancestry.com or 23andMe, because that seems to be what changes my practice these days a lot. And we're now in a conundrum with the court about what to do with the person that's not suddenly known as a genetic father. There's just so many variations to that story as to how it comes in front of the court. And the court has to struggle with, do we just remove this child now to a parent the child didn't know for 10 years, who suddenly is a genetic father? The prior genetic father, what do we do with him? Does he get any rights? Often he's relegated to a chapter we call third-party visitation chapter, which is a very limited amount of time with the child. Because of constitutional rights as a parent, you get a lot more as a parent than just a third party who's visiting the child. As an example, I had a grandparent case where they ended up with 1 weekend a year out of the entire jury trial, or not jury trial, but entire trial in front of the court. And so, if you've been raising a kid for 10 years, you don't want to be relegated to 1 weekend a year, obviously. But that's just one primary example of a lot of the reasoning behind this bill. I know it's a lot, and I know there's probably a lot of confusion as to why things are in here. But the big picture is to give us, the attorneys, and the courts, the judges, the opportunity to decide what's in that child's best interest, parent-wise, who that child recognizes as a parent, who that child needs to continue a relationship with, and also to assure that parents on the front end are given a fair opportunity to show they are parents. All of our DNA genetic testing statutes are really old, and as you can imagine, science has changed over time and really quickly. So there's a lot of language in here we don't have, and now we do if we pass this. So it modernizes us. It gives us the opportunity to get in front of the court and just argue what's best for that child in terms of parentage. And with that, let the questions roll, I'm sure.
Thank you for that. We do have a few questions. The first question will be from Assemblyman Gray.
Thank you, Madam Chair. So it's funny, ma'am, you kind of hit on where I was going with it. You've got a parent that raises a kid for 10 years thinking it's their own, maybe because the mother wants them to think it is, or just they believe it is. So will this address, and give them further rights? And on the converse, if they were duped, will it allow them to step away?
Yes, Kimberly Surratt for the record. It will do both. And the beauty of that is it will give some parental rights to that person who thought they were a parent and they didn't. It also, there is a provision in here regarding if it was fraud and what we can do with fraud. There is, if you've been raising the child and holding the child out as your own for more than 2 years, your standing is solid, but there is some language in here that assists with that, the duped part of it, the fraud part of it, which we haven't had anything great to hang our hats on for that, other than we've had a little bit of case law and a little bit of assistance on the fraud on that end of it, but nothing that helps us within the family law context specifically.
Thank you. And I got to say, any parent that thinks they were a parent, for no matter how long they acted as a parent, and they want to step away, they're dirtbags.
Our next question is from Assemblywoman Newby.
Thank you, Madam Chairwoman. I was looking at, let's see, it's page 36, section 107, regarding sub 6, the gestational carrier. And I was wondering, in a contract between the gestational carrier and then the parents, does this hold when all three parties are in Nevada? What about when a gestational carrier is not located here, or parents aren't located here, or even when perhaps the gestational carrier is in a different country?
Kim Surratt for the record. Easiest question I could possibly answer. That is almost 100% of my practice at this point. There are huge sections of the surrogacy statutes that are not included in this because we already adopted the changes. So you're not seeing those, which would probably fill in some of those holes for you to notice. But we do have, for parentage, for a gestational carrier agreement, which a lot of people call a surrogate also, we have our jurisdictional rules say that we can take jurisdiction if the intended parents reside here, the carrier resides here, the child is born here, the child is expected to be born here, or the fertility treatments that caused the pregnancy occurred in the state of Nevada. And so we have pretty broad jurisdictional, where we can hug our arms around that. So we will have intended parents who reside in other states and other countries utilizing gestational carrier in the state of Nevada. You're welcome.
Thank you. Our next question is from Assemblyman Urick.
Thank you, Chair. And thanks for being here this morning. I was looking at section 101 on page 30. And just had a quick question. I confess I don't know this area of law very well, but it's definitely interesting to read through some of this stuff. And as I'm looking at section 101, it says specifically that a person who intends to be a parent born by assisted reproduction has to be in a record signed by the person giving birth to the child. And the person who intends to be the parent of the child. And a failure to consent to that type of record doesn't preclude a finding from the court. And I see in section or subsection A there it talks about clear and convincing evidence, but more specifically in B it says during the first 2 years of the child's life, you're adding language including any period of temporary absence they resided together in the same household and the child was openly held out. So again, to try to clarify it in my own mind, I guess it's a two-part question. Can you confirm what is the record, right? I mean, is it a contract that's drafted up? How formal does that record need to be? And then two, what is the purpose of adding that specific language of including a period of temporary absence?
Kimberly Surratt. Thank you, Assemblyman, for those questions. A record, so the assisted reproduction statutes are not just surrogacy, it's also egg donation, embryo donation, sperm donation. It can be that even an unmarried couple, they don't want to get married, but they want to have a child, they're utilizing fertility treatment. Parental, we do agreements for parentage. We do those donation agreements says the donor's not a parent and the recipient is a parent. That holding out, that temporary not being in the home, there's multiple things we've seen over time, and actually you guys are going to get to hear this when I do the adoption rewrite during the same session too, where maybe the child's in the hospital, not really in the home. We have had judges get so particular on that in the home part for us and other provisions and other statutes. Military could be also parents not necessarily there. There could be, could have been a custody battle that the child was not in the home for a bit until they figured out exactly what was going on for that. Yeah, I mean, there's a lot in family law. That ability to flex with the facts and circumstances. Our families are so different. I could go on probably for hours with examples of strange moments and things that we just don't need to be tied into, you know, a judge saying 100% in the home at all times, right? Yeah.
Thank you for that. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for diving into this really important work and updating our statutes. I also had a question on page 36, sub 6. I understand surrogacy is a very tough section of law, and I totally agree with a right of a person over their own body. My question is, though, does that mean that the gestational carrier could choose to drink or smoke or do something that harms the fetus under this? I know that's kind of a gray area.
Kim Surratt, she just asked me if we wanted to have Ms. Jocelyn answer that, but surrogacy is all I do. Again, same situation again. where you're not seeing all the rest of the gestational carrier agreement surrogacy statutes that we do have in here because we didn't modify all of them. So there are other provisions that restrictions on stuff like we don't want you to do meth while you're pregnant, preferably, are still covered within our other statutes. This one is really, we already have that the carrier can choose her own obstetrician in consultation with the intended parents. My pitch to intended parents when they start worrying about, well, what is she going to do with her health? What if she picks a really bad doctor? Well, if you're a woman who's pregnant and the doctor creeps you out, you don't have to go to that doctor. You get to pick who. It's a very intimate relationship for anybody that's had a child would tell you. And big medical decisions, she still has autonomy over her body. We do not get to interfere with her autonomy. That child, when the child's born, the intended parents have the right to make all the medical decisions for the child. We do try to contract around that some to get everybody on the same page with the same mindset, with a meeting of the minds about behavioral decisions, such as doing illegal drugs while pregnant or drinking. But it's a contract. It is not necessarily enforceable from a constitutional perspective. I can't come and force you to drink one thing and not another, whether you're pregnant or not. And same thing here. These are the really big decisions in this paragraph, whether to have the cesarean section, whether to, what else is here? Transfer multiple embryos, that's a big one. So if you think of, everybody kind of knows about Octomom, right? Where the doctor transferred too many embryos. That is a big no-no now in the reproductive world and in the gestational carrier surrogacy world. We contract to say how, many of our surrogates say they only want a single embryo transfer, and a lot of our doctors now say they will only do one unless it's absolutely, the embryo is in such poor quality that maybe 2 would be justifiable. Beyond 2, that's bad behavior to have in the contract, but we want her to have the control over whether it's 1 or 2, and she should have a right to decide. Now, a single embryo could split, and she could be pregnant with twins. We go over that, we discuss that, but that's also the reason why many carriers will pick a single embryo transfer. Intended parents will tend to want to control all factors, but that's a huge impact on her body. Carrying twins is not easy at all, and so we want her to have that control.
All right, not seeing any additional questions. Did you want to respond, Assemblywoman?
I want to see if Professor Jocelyn do you want to just add anything, Professor?
No, I'll just add that I thank you, Assemblymember Cohen, for doing the incredible work to introduce this bill. I know it was a lot of work, and I'm happy to answer any additional questions that arise. Thank you for your consideration.
Thank you. And with that, we don't have any additional questions. So thank you for your presentation, and I will open it up for testimony. So anyone here in Carson City that would like to testify in support of Assembly Bill 371, please come forward. Not seeing anyone. Is there anyone in Las Vegas? Broadcasting, will you open the lines, please?
There are no callers at this time.
Thank you. If there's anyone here in Carson City that would like to testify in opposition of Assembly Bill 371, please come forward. Not seeing anyone. Is there anyone in Las Vegas? Broadcasting, is there anyone on the line that would like to testify in opposition?
There are no callers at this time.
Then I will open it up for testimony in neutral. Is there anyone here in Carson City that would like to testify in neutral? Anyone in Las Vegas? Broadcasting, is there anyone on the line?
There are no callers at this time.
Thank you. With that, I will welcome back Assemblywoman Cohen to make any final remarks.
Thank you, Leslie Cohen, Assembly District 29. Thank you to the committee for hearing the bill and for reading it. I know it's a long one. It was a lot of work. Thank you for Professor Jocelyn for your work on UPA and for being here today. And thank you as well, Mr. Rott, for all your work over the years. Mr. Rott's just done so much for family law in this building for our state over the last several years that was unpaid, and just to make sure that we had better laws for our families in Nevada. So thank you.
Thank you so much, Assemblywoman. And with that, I will go ahead and close the hearing on Assembly Bill 371. The last item on our agenda today is public comment. Just a reminder that public comment is not to make further remarks on any bills that we heard today, but to make comments about anything that's under the purview of this committee. So is there anyone here in Carson City that would like to come forward and make public comment? Maybe I should define it a little further, that if you've been sitting here in the committee room and you're thinking of issues that fall under the Judiciary Committee, like criminal justice, or I think criminal justice is a big one, but also often we deal with matters with gaming and casinos and HOAs and all of those matters. If you're thinking of anything you've ever wanted the legislature to hear about, your own personal opinions, this would be your opportunity to say it publicly, if you so choose. Not seeing anyone coming forward in Carson City. Not seeing it, but we're so glad to have you all with us today. Not seeing anyone come forward here in Carson City. Is there anyone there in Las Vegas? Not seeing anyone in Las Vegas. Broadcasting, please open the lines.
The public line is open and working, and there are no callers at this time.
Thank you. Well, with that, then I will go ahead and close public comment. We have finished our business for the day. And just a reminder that we will all be back here at 8 a.m. tomorrow morning. With that, this meeting is adjourned.